In the world of industrial relations, there's this constant tug of war, right, between employees and employers. And when things really break down, each side has this incredibly powerful tool they can pull out. For the workers, that's the strike. And for the employers, it's the lockout. Today, we're going to pull back the curtain and see what they are, how they actually work, and who really holds the power. So what is the real difference here? A strike? A lockout? I mean, from the outside, they can look almost identical. Work just stops, the gates might be closed, and nobody's getting paid. But legally, and in terms of the power dynamics, well, they couldn't be more different.
All right, here's our game plan. First, we're diving into the strike. That's the workers' tool. Then we'll flip the script and look at the lockout, which is the employer's countermove. After that, we'll get into the really strict rules of engagement for both sides, before wrapping up with why these definitions are so incredibly important for the balance of power.
Okay, let's kick things off with the worker's main tool, the strike. At its very heart, a strike is all about using collective power to try and force a change. So the official definition from India's Industrial Relations Code. It sounds a bit technical, but it really boils down to two key ideas: a cessation of work and acting in combination. Put simply, a strike isn't just one person deciding to walk off the job. No, it has to be a group of employees, all acting together with a kind of shared purpose. So for a work stoppage to be considered a legal strike, four things really need to be in place. First, it's got to be a group effort. Second, work has to physically stop. Third, everybody involved needs to be on the same page. That's the common understanding part. And finally, it has to have a clear goal. Whether that's to push for certain demands or protest a specific problem. Now, here's where things get really, really interesting. There's a huge change in the new labor code that all hinges on this one number, 50%. What in the world could that be about? This is a game changer. See, in the past, workers might organize a mass sick-out or something similar, taking coordinated leave to stop production without officially calling a strike. Well, the new code basically closes that loophole. Now, if half the workforce or more takes casual leave on the same day as part of a coordinated plan, the law says, nope, that's a strike. And all the rules that apply to a formal strike now apply to this too. Okay, so that's the employee's move. Now, let's walk over to the other side of the tug-of-war rope and look at the employer's equivalent power play, the lockout. And here we have the parallel legal definition. A lockout is when the employer starts the work stoppage. They might literally lock the doors, they might formally suspend operations, or they might just refuse to let their employees come to work. It's really the mirror image of a strike, but it's initiated from the top down. The key elements are pretty clear. It's started by the employer, and this is super important, it has to be temporary. Just like a strike, it's a tool of coercion. It's a weapon designed to put pressure on employees to accept the company's terms. And this is a really critical legal point. A lockout is not the same as a business shutting down for good. Think of it like this. A lockout is the pause button. The employer fully intends to hit play again once they reach an agreement. A business closure, on the other hand, is the stop button. It's permanent. End of story. So you've got these two very powerful weapons. But this isn't the Wild West. You can't just wake up one morning and call a strike or declare a lockout. The law has very clear, very strict rules of engagement for both sides. And it really comes down to two absolute must-dos. First, whichever side is making the move, they have to give proper advance notice. Second, and this is a big one, if there are formal negotiations happening with a third party, what are called conciliation proceedings, then strikes and lockouts are totally forbidden. It's like a legally required timeout. And these rules have some serious teeth. If either side just ignores these procedures, their action is immediately considered illegal, and that can open them up to some pretty significant penalties. The law is basically trying to force everyone to the negotiating table before they can shut down the whole operation. Okay, so let's just lay it all out side by side to make it crystal clear. You can see the fundamental opposition. Who kicks it off? What's the action? What's the goal? And it really highlights those key legal details we talked about, that 50% mass leave rule for strikes and the absolute requirement for lockouts to be temporary. So after all this, why should we even care about these super precise legal definitions? Well, because they're not just technical jargon. They go right to the very heart of the balance of power in any workplace. This really says it all. These definitions, they aren't just words on a page. They are the legal blueprint for conflict. They spell out, very clearly, not just the rights, but also the limits of power for everyone involved, from the shop floor to the corner office. And that brings us right back to our tug of war. If you really want to understand labor relations, you have to know these rules. They tell you exactly where the line is drawn, who's allowed to pull on the rope, and precisely when they're allowed to pull it. It's like the fundamental grammar of any industrial dispute. So, we're left with this one last big question. The law sets up a framework with rules and tools for both sides. But in this ongoing tug of war, who do you think really holds the power at the end of the day? That's definitely something to think about.